In this video, we're going to talk about the next standard for something to be patentable under U.S. patent law, and that's called the standard of novelty. In order for an invention to be novel, it has to be the case that no single piece of prior art teaches each and every element of your claim that you're going to draft to try to cover your invention. Prior art is something we're going to discuss more specifically in another video, but generally speaking, something is prior art if it's publicly available information related to your technology that predates either your date of invention or date of filing, depending upon which patent law we're looking at, the old law or the new law. Prior art can be other patents, scientific journals, public presentations, or even a sale of a good in the marketplace. If a piece of prior art teaches each and every element of the claim you're going to file at the patent office, we say that that piece of prior art anticipates your claim. So you'll often hear people refer to the lack of novelty as anticipation. So let's say you come up with an invention and you're trying to figure out whether it's really novel. Now, the first thing that many entrepreneurs do mistakenly is that they assume because no one is offering a similar technology on the marketplace that your technology is new. Now, it may be new from a business standpoint, but it may not be new from a patent standpoint. And that's because prior art can include other things besides what's been actually offered in the marketplace. There may have been someone who wrote an obscure scientific journal article that disclosed your technology, rendering it not new, even though it could be new in the marketplace. The other thing you're going to do is you're going to think about your invention in terms of elements. So what are the 4, 5, or 6 essential elements of your invention that someone would have to include on a piece of technology in order to practice the essence of your technology? You're going to look at those elements when comparing your potential patent claim to the prior art. Let's look at an invention we're familiar with, Gillette's razor blade with progressive blade technology. And we can look at the claim that we examined in some of our prior videos. So even though Gillette may not have filed this patent yet, when they came up with the invention of their progressive blade technology for a safety razor blade, they may have started thinking about it in terms of these elements: a guard, a cap, a group of first, second, and third blades, and then the particular geometry for each blade that gave it its progressive blade geometry. If you were trying to figure out whether this invention was novel, you'd think about it in terms of these elements, and then you'd go back and look at prior art that relates to this area of technology. Perhaps other patents filed by competitors, perhaps scientific journal publications related to cutting technology, things like that. And if you found a piece of prior art that you thought taught something similar to what you were contemplating claiming in a patent application, you'd compare that piece of prior art to your elements that you've identified as essential for your claim. And you'd go through that prior art and see if it discloses a guard, a cap, a group of first and second and third blades, and then the progressive blade geometry that's described in the last 3 elements of this potential claim. If that piece of prior art teaches each and every one of these elements, then it anticipates your claim. That means that the claim, as you're thinking about it right now, would not be patentable because it lacks novelty. Now, that doesn't mean you can't get a patent on your technology. What could you do? Well, you can add elements to your claim. Perhaps you can add more detail to these existing elements, or you can further describe your invention. By adding elements to your claim, you're making it easier to avoid the prior art, easier to convince the patent office that your invention in fact is new. Now, on the flip side though, as we'll see when we talk about infringement and the scope of your patent rights, by adding elements to your claim, you're making it easier for a competitor to design a product that doesn't meet each and every element of your claim. Therefore, you're narrowing the scope of your patent rights. This was a general overview of the standard of novelty in order to obtain a patent in the United States.